Hello everyone, and a very warm welcome to the latest in our RSK Biocensus series of webinars, the First Thursday Club. And today I'm very happy to be introducing a couple of people from my team. So I'm John Davis, I'm a director of RSK Biocensus and also head up the RSK Wilding team, within which Natalie and Tim sit. And we're going to be talking today about our role as a responsible body, which is a pretty new thing, and also conservation covenants. And it should be hopefully pretty interesting. I'm very interested in this. Now, if you can move on to the next slide, I shall introduce you. So Tim basically covers off the ecological side of this, has an ecological restoration background and a conservation background, and has been doing a lot on green finance for us in Wilding. And he's also got a regulatory background, having been at the OEP for a short time. And Natalie is very much the legal brains behind this and is instrumental in getting us the responsible body status, and also is drafting up the conservation covenants and terms and conditions and all the legal stuff. So perfect people to be talking through what this subject is all about. Before I hand over to them, I will quickly run through the normal housekeeping. So your microphones are off, so we won't be able to hear you, but do please ask questions, pop them into the Q&A box on the right of your screen. I will sift through those whilst the talk is going on, and I will put the juiciest ones to Tim and Nat at the end. I'm really hoping we get 10, 15 minutes of questions. Any that we can't get through, we will respond to you offline by email. And the last thing to say is that there will be a feedback form winging its way to you about I was going to say a week, about an hour after the webinar, and you will be able to fill that in if that's possible. That'd be great. Right, if you guys want to turn off your cameras, I'll do the same, and I'll hand over to you, Tim, to kick us off.
Thank you, John, and thank you all. So yes, so Nat and myself will take you through a quick introduction, setting the scene. There's going to be chunky kind of set of details about the responsible body conservation covenant, so that nitty gritty will be covered by Nat, who's the expert there, and then we'll be coming back to myself just to kind of round up over the benefits and also the sort of some of the wider applications at the end. Next slide, please, Nat. Okay, so sort of setting the scene in the introduction just starts with, I suppose, a change of pace and where these nature markets are coming out of, basically. So there's a lot of interest, right from the global down to the local. Importantly, obviously right now we're seeing this through the BNG market and the fact that that's kind of gone live, but there's all this other interest basically in terms of how nature finance can actually help sort of fund nature recovery, and all of this eventually comes to outcomes on land basically, and obviously we're seeing this through government policy in terms of green finance strategies, and obviously the direction overall in nature conservation to see how this can help fund restoration basically. Okay, so why us? Importantly, if you want to skip to the next slide, so obviously why us? Why were we thinking about this? I don't need to reiterate RSK Biocensus. You know, we're experts in ecology. So with RSK Wilding as a sort of elite force business unit in RSK Biocensus, it just made sense to use our sort of excellence and complementary skills, basically. You know, this monitoring, etc. And next to the fact that we're looking out and seeing how we're, you know, this complexity of BNG, but lots of the other things around that it applies to within nature recovery and restoration is a large business opportunity. And one of the things with BNG that we offer is this kind of complete cradle to grave approach. Basically, we can kind of support anything and everything, especially the more complex, the more we love it, basically. Now, these skills in the background are obviously hugely critical in terms of the kind of standards and the applications around conservation covenants, obligations being delivered and things. So to us, it absolutely made perfect sense. So it's critical aspect for us, and maps really well to nature recovery and application and conservation covenants. So BNG, as I slightly alluded to, is basically the kind of starting point for this because it's so live and it's so relevant right now. So if we go to the next slide, this is the kind of first application, and conservation covenants came together as a kind of package with the legislation for BNG, all under the Environment Act 2021, and it's part of this bigger kind of ambition. So in a way, you see conservation covenants and responsible bodies, because of that, sort of sitting with this way of helping secure long-term gain on land, and it fits into this sort of much wider kind of governance situation from the Environment Act for England, basically. So next slide, Nat. Okay, I'm not going to say and explain sort of wider biodiversity net gain. You'll have all seen this this diagram in one way or the other. Oh, sorry, go back. So a little bit ahead of myself there. So in effect, the conservation covenants come in at a really important point. After the buildings, the lovely buildings representing the development, obviously we've got the trees representing habitats. So in terms of securing no net loss and net gain, those trees in effect in the diagram are secured potentially through conservation covenants. Section 106 can play a role, but as these things get more complex, conservation covenants are going to come into play, basically. So next slide, and I'll let Nat take over basically and get into the nitty gritty now that you want to hear about responsible bodies.
Hi, I hope everybody can hear me. So I'll explain a bit more about responsible bodies and conservation covenants and sort of the legal application really. So we were officially approved as a responsible body on the 23rd of February. I know that there were lots of people wanting a whole bunch of responsible bodies to come through, people waiting to get planning permissions and people needing it for biodiversity net gain. So there have been a few now, and we would hope that there would be more in the future as well, so the system as a whole will work. And a responsible body, it's hard to tell what it is just from the name. A responsible body is an organisation that is appointed by DEFRA, and they enter into contracts over land for the protection of the land and the enhancement of conservation sites. And that's quite a wide term. It can be conservation in terms of heritage, it could be, you know, any kind of buildings, it could be a community culture even. It's just, yeah, quite a wide application. So the responsible body will enter into these contracts called conservation covenants, and these get registered as the local land charge. So when you buy a property and you look at the title of the property, you look at the land charges register on it, and it will say what charges there are over land, and the conservation covenant will appear there, which means it's then binding on all future owners of the land. So it's a way of legally securing the site and the aims and the goals of the site. The responsible body is also in charge of overseeing and monitoring that contract, essentially. So saying, what is the site meant to achieve? What are the aims and goals for the land? And the responsible body has to just monitor that that is being achieved. And conservation covenants can, in theory, be indefinite. It can last in perpetuity, or they can last for a defined period of time. In relation to biodiversity net gain needed for planning, if you have to have 10% biodiversity net gain for your planning permission, then the conservation covenant should last a minimum of 30 years. So the responsible body, after entering into these covenants, submits an annual return to DEFRA, and that just means that we have to declare what habitats are that we're overseeing, how many we have, where they are in the country, and you do that each year. So as well as being tasked with the monitoring and compliance, any breaches of that contract are also enforced by the responsible body. So I'll talk more about that later on. Who can be a responsible body? So again, quite wide. It's moving the regulatory system really into the private sphere. So it has to be a body that's UK based, but it can be a public body, it can be a local authority, it can be a charity, it can be a private company. But you have to, in your application process, prove a number of points. You have to prove that some of your main activities relate to conservation, that you have financial security, that you have the operational capacity. So that would be, you have the expertise in your house to deliver that, and the ability to enforce it as well, and also that you have a track record of doing these things before. So, you know, a lot of new companies would find it a bit tricky to pass the application process, because you have to prove that you've got an ability to do this and you have been doing it for a while. In terms of ongoing suitability, so there isn't any oversight from DEFRA. They don't come and say, are you doing your job properly? Can we review your files? There's no kind of audit process, but there will be a continuing ongoing suitability need. So to reapply, you need to prove that you continually meet the criteria. Now that leads us on to conservation covenants, which I think are very exciting. When I talk to them with other lawyers and say, now we have these positive contracts that can bind future owners, then lawyers get very excited about it. I don't know if other people get quite as excited about contracts over land. So where did they come from? Conservation covenants. Previously, there was just a bit of a hole in the law. So you have historically covenants on land can bind future owners only if they were restrictive, which means that if you bought a piece of land and you had an obligation on the landowner said, you must not do this, so you must not use this property for commercial use, you must not keep poultry on your land, they can range quite massively. That would then bind future owners of the land. They get entered on the charges register as a restrictive covenant. Probably most people have seen them when they buy a house or when you buy agricultural land, even though you can have restrictive covenants on them, but not positive obligations. So positive obligations would not bind future landowners. So you could contract with your neighbour and say, I will agree to upkeep this area of a fence, but that would only bind you. It would not bind any future owner. So we had this sort of funny system where only restrictive obligations would bind land, and you could also have what's called easement, so a right of way. You could have a positive obligation if it benefits a neighbour. So you could have a right of watercourse over somebody else's property or a right of way over somebody else's property. But that was really it. And when you're looking at the government's bigger goals of net zero and long-term environmental goals, there needed to be this way of introducing positive covenants that bind land. So that was the background of them. And they were not just introduced for biodiversity net gain. And I think that there's been a focus on biodiversity net gain because of the update in the planning law, but actually conservation covenants were introduced for so many uses. And the Law Commission said, there are lots of situations that sit outside of the planning process. And when you have not a planning obligation, that sits within the planning process. But when you've got situations that fall outside, there's nothing there's no suitable legal method of dealing with them. So, for example, if you had a heritage trust restore a house and they wanted to sell it to a private owner and they wanted the regular upkeep of that property, that regular upkeep would be a positive covenant. And actually, it wouldn't be legally viable because that wouldn't fall to any future owner. So you had these complicated systems where either you had to get a Section 106 agreement for certain things, but if it fell outside of what that would cover, you ended up with these complicated methods of leasing land and then having a charge back arrangement, a lease back arrangement, and then indemnities between different landowners, and it all became very complicated. And they said, let's just put conservation covenants in where we can have something positive that runs with the land. So conservation covenants, I've probably covered some of this already. Private agreements, they say what can and cannot be done with the land, and it would bind the future owner. So in theory, for example, if the conservation covenant lasted indefinitely, if that landowner went insolvent, for example, or bankrupt, it would go to the administrator in bankruptcy and then pass to the next future owner. That could be an example of how indefinite they are, unless you have some kind of break clause. So other countries have lots of similar systems. In the US, you've actually got millions of hectares covered by what they call, I think they call them conservation easements. And the agreements, so in the UK, the conservation covenant can be very flexible, put any clauses in it that you want, as long as it's for the public good, and that's not really defined, and has a conservation purpose. And again, that's not really defined in the law. So very flexible. And it can be for environmental sites or it can be for heritage sites. So a question that we get asked a lot is, what are the benefits of a conservation covenant over a Section 106 agreement? For those who aren't that familiar with planning law, when you apply for planning permission, you'll get planning conditions, usually very narrowly worded conditions about what needs to be done. And then you'll also have planning obligations, which are a separate document, which can have positive and negative obligations in them, and they can bind future owners. So a lot of people say, well, why? What's the difference? You know, why are we using conservation covenants when we know the Section 106 process? And the Section 106 tool is actually a really useful tool. You know, we're not criticising it. There's a really useful tool. It can require steps to be undertaken in relation to planning that are really essential. And if something sits within the planning process, then it can be really useful. But there are certain restrictions on it. So if a reason for granting planning permission is also combined with the Section 106 agreement, then they have to be necessary, they have to be related to the development, they have to be fair in scale and type, and local planning authorities usually have their own standard precedents that they use, and they're also going to be slightly bound by their own planning policy. You've got your national planning policy, and then you've got your local planning policies. And so if you're contracting with the local planning authority, then there are going to be certain restrictions on that. And for that reason, the Law Commission said we need more. And there are, again, like I said before, so many other situations that are going to fall outside the planning process that cannot be covered by a Section 106 agreement. In relation to biodiversity net gain, the Law Commission basically said the use of planning obligations is too limited. It can only be enforced by the relevant planning authority. It only applies within that geographical area. So if you've got, say you wanted an off-site area that span across, you know, it was a cross-boundary one, so you had two local authorities in the area of land that you were working with, that's quite complicated because you've got to then include both local authorities as part of your Section 106 obligation. So they were sort of seen as a slightly imperfect tool because they were restricted to the planning context and only had to meet strict criteria. And the Law Commission wanted to move away from the public sector to the private sector. So the main benefit, and the biggest reason I think for conservation covenant is its scope. So when drafting a conservation covenant, to be honest, it doesn't have to look anything like a Section 106 agreement. It can be really, really flexible. You could have a situation where you just wanted to preserve an area of rock climbing for public use, and you can have all sorts of clauses involved as long as it's for the public good and the conservation purpose. So flexible drafting, you can have a lot more clauses about management, third-party fees. So with a Section 106, you make payments to the local authority, and you can claim those back if it's not used at the end. So that's actually really good. But with a conservation covenant, if you have complicated management plans where you want to include other third-party payments, then that can all be included in a conservation covenant. So yeah, the flexibility is really good, and the wide range of clauses you can use. They can also be used for more complex situations relating to other natural capital. So you could have nutrient neutrality, you could use them for stacking, you could use them for carbon offsetting, flood mitigation, management, all these other things that people need to do with the land that maybe would be a bit difficult under a Section 106 agreement, or maybe fall outside it, then you can use with the conservation covenant. They are enforced in a different way. Instead of being enforced against a local authority through their appeals process, they're enforced through private contract law, which we'll come on to in a bit. So I'll move on. I think I've probably covered this one already. Our approach as a responsible body. So our team, this process has really started up by myself and Tim, who were heading it up, and we sit within RSK Wilding, and we're part of the large RSK biosensors. So we've got, you know, access to all the expertise that sits there. Yeah, we are currently playing catch up. So we did get notified 6 weeks early from DEFRA, which was kind and unexpected. So we've had a lot of new inquiries, but we were sort of catching up on our internal processes and templates, but that is all coming together now, which is good. And I'll talk a bit about our general process. So if somebody comes to us and says, actually, we've got this area of land and we would really like to have a conservation covenant on it, what do we do from here? We would get some initial information. So we really need to have a review process to get an estimate of costs, because as the regulator and the enforcer, the risk to us is, we've got three risks really. We've got the risk of the land being sold to another owner and being outside of that sort of control. We've got the risk of financial instability of the landowner or the land manager, and then we've got also the risk of just a breach of covenant, whether that's intentional or unintentional. You know, there might be things that go wrong on the land. So we're looking at that risk. So before we enter into any agreement with anybody, we're just going to have a little look at the information and say, right, what's the likelihood of anything going wrong? Because if there's more likelihood of things going wrong, that would affect our cost schedule, because we might need more monitoring. That's basically it. So once we've got into the once we've come to an agreement about costs, then we look at just doing the legal agreement. And we've had a lot of inquiries saying, you know, can we just have the conservation covenant as in a similar way to when you get a section 106, can we have the agreement if we start entering into this? There is before that just a bit of a due diligence process that we have to do, which again is a bit of a risk evaluation. So it's looking at the investigation of the title of the land. From our perspective, we want to know that this is going to work. We want to know that there are no other covenants on the land that are going to interfere. We want to know that there are, you know, if it sits within local conservation policies or near to certain water sources, or if there are any other legal restrictions on the land, how that's managed and if it's workable. So in the due diligence process, we would look at the investigation of title, and most likely, you know, the landowner has done all that already. You might, if somebody's creating a habitat bank, for example, they would have bought the land, they would have done all their local searches, they would have done their environmental drainage searches, things like that, in which case we would review those documents and just make sure that we're really happy. You might, you know, we also could have a client that's, say, a farmer whose land has been in his family for generations and hasn't actually looked at the legal title for a very long time, in which case we would want to do a bit more of an evaluation. And then our ecologist would also just want to quickly review the HMMP, so that if you have a management plan for the land, and what the plans are for the land generally, if it's viable, do we think that that is going to be a long-term workable solution? Have they thought about contingency plans? What if there is an invasive species coming in? What if things happen that are unexpected? Can we make sure that we've understood absolutely everything that's needed before we then go into the covenant? And then that will be drafted and agreed between ourselves and the landowners or land management or both legal team. And then once we've all agreed it, it will be submitted to the land registry and registered as a land charge. And then we go live and we have our conservation covenant. And then that binds all future owners. And then we are tasked with the monitoring and enforcement of that. Our monitoring can be either the actual monitoring of what's going on the land. So we might have a landowner that says, I'd really like to create this habitat on my land. I'm happy to do the habitat creation, but you know, I would like to work with you going forward to monitor, in which case we would do the actual on-site monitoring and to make sure that everything is going as it should. It might be that we're contracting with a landowner or a company that has an awful lot of land and has their own huge team of wonderful ecologists, in which case they might just want a sort of tick box compliance exercise, in which case we would be monitoring their monitoring, if that makes sense. And for that, the cost would be different. So that's going to be our two-level of approach. And that is, again, is going to vary depending on the risks involved. So next slide. Enforcement. Enforcement is always quite a big question for everybody, because the Section 106 process is very well known, but if something falls out of the planning process and you need a conservation covenant, or you've chosen a conservation covenant because of the benefits of them, then what does enforcement look like? And it actually falls under contract law, so it's not within the public law process. So what we'd have to do basically is enforce it the same way a breach of contract is enforced. And our approach to that is going to be really very much risk management and mitigation at the beginning, and that will include having a really good relationship with the landowner. So what we'd like to do is approach this from a very collaborative perspective of saying, okay, we would like to help advise on the delivery of the land, or if you would just like compliance, then we're happy to do that as well, but we want an ongoing relationship to say, how is this going? Is there anything that we need to do to adapt this. Is anything going to go wrong? Do you have any concerns? Maybe 5 years down the line, things aren't looking the way that you thought they would look. Let's have this ongoing conversation so that anything going wrong, we can manage that and agree a way around it. And because this is a private contract, the agreement, you can vary it on agreement at any point. So to have that ongoing relationship, to be able to say, we're going to be, on the other side of the phone anytime that you think things are going wrong, so that we can meet any issues early on. If things do go wrong and we think actually there's been a breach here and we're not happy about it, again, we're really not looking to go and take people to court immediately, because that it doesn't help an ongoing relationship. Nobody comes out of court feeling like they've won, even if you have won. It always breaks down the relationship. We'd want to start with negotiations, essentially. If we can't negotiate a way forward, we look at alternative dispute resolution, such as mediation, because again, a roundtable meeting is a lot more of a healthy way forward, really, than going to court. We'd look at negotiating with other lawyers involved as well, if that helps, and then only at a very last resort would you look to litigation. And to be honest, if you can't do anything by mediation, you'd get an expert report to say what needed to be done, and only really if the landowner is refusing the expert report do we end up in court process, and that's going to be incredibly rare and unhelpful in most situations, because then what you're doing is diverting the costs that could go into remedying the breach on the land. The costs are then going to the court fees and the legal fees, which we don't want. But that would be our approach anyway to enforcement. And that's the legal side sort of wrapped up. So I will pass back to Tim.
Thank you, Nat. So now that Nat's finished the chunky business, I'll just quickly round up in effect. So obviously the title of the slide is about the benefit to landowners. So I'll just reiterate a little bit about that and move on to some of the sort of wider application we're having conversations about. So you'll probably have picked up on these basic benefits through the course of Natalie's slides, basically, but they're just very flexible as legal contracts, basically. So in terms of fitting the requirements of landowners, complex sort of third-party arrangements, how you kind of coordinate across clusters of landowners and things, all of that becomes much more possible outside of the planning system, basically. Obviously, one of the big things is about security and confidence, especially thinking not just sort of BNG, but the much wider applications that might go on in the future. It gives a lot of confidence, basically, in terms of the funders and investors, and that's the route that lots of things are starting to sort of look, basically. They can be business suitable, so in terms of different business models, different needs, that flexibility can fundamentally be managed. You can fit it into anything, basically. So there could be an approach with a conservation covenant that becomes your kind of model that works for you, and then it's just sort of the HMMPs and things like that that are appended. Obviously, a lot of different public benefits, basically, and they can all be together. They could be separate. It's independent. So obviously, in effect, what's being introduced now is a new, slightly independent way of regulating some of these aspects. So it doesn't have to be within the government or agencies. It does raise a strict question of us being leaders and standard makers as a regulator, but that often could be something that certainly in terms of log jams and delays we can help with. It's very adaptable. Obviously, Nat mentioned mutual agreement at any time. You can update it, review windows, especially thinking about environmental land management over 30 years. All kinds of things change, climate change. So that's built into this. It's not fixed. And then importantly, while this very much isn't, I suppose, a benefit because of the conservation covenant, one of the questions that comes along with this, especially linked to sort of estates and large sort of agricultural businesses and things, is being where tax and natural capital sources of funding kind of sit. So the government, luckily, at the last budget, issued a report that starts to clarify all of that in terms of how it relates to sort of agricultural relief, inheritance tax and things like that. So that was an important step as well. So hopefully you're seeing a kind of very flexible picture, basically. And then Next slide. And basically, just those kind of wider applications. We've hit on this throughout the slides and what Nat's been saying as well. So there's a lot of potential applications. Now, we're basically hearing and having discussions about everything on the slide to some level, but obviously front and center is BNG, and then basically along with that is nutrient neutrality. That's what most people are talking to us about, but lots of the others are all there, and we're interested in how conservation covenants can apply to them. So if you've got questions, yeah, that's going to be, you're more than welcome to get in touch with us about any of these kinds of uses and anything that you think they might work for as well. So last slide before we hand back for questions. Basically, obviously you've got our contact details here if anybody wants to quickly take those down. And thank you for listening. The big chunky questions now, basically, and let's see how we can help answer those, I think. And back to you, John.
Brilliant, thank you both. If you want to turn your cameras back on, both of you, I have had some questions, which I will put to you. Good timing. You did that in half an hour, pretty much spot on. Okay, so the first one is perhaps an obvious one, which is around the cost. So how much is it going to cost is kind of the broad question, and I'll kind of weave into that a bit of a separate question that was similar, which is, are your costs standard or bespoke?
Okay, yeah, so obviously this is one of the first questions that we get with the inquiries, basically. So we've been doing a lot of work about what the kind of real costs are of this sort of new enforcement compliance regime, basically. So Nat hit on a lot of the aspects of risk, and that kind of fits into our costs, basically. So where things are sort of high risk, more complex in terms of sort of habitat outputs, thinking BNG here specifically in terms of costs, then obviously there might be more sort of verification site visits and things involved over 30 years, in which case the costs are slightly higher. So we've basically got these brackets by level of risk, low, medium, high kind of thing. So they largely,
Tim, this all has to get discussed and sort of negotiated when you're putting together the covenant, because
absolutely. So it's about the information that comes in. We can kind of be quite bespoke, schedule of costs sort of estimation at the beginning, and then we get all the detail in terms of due diligence. So what we're looking at roughly is, I think it works out about £1,600 a year or £48,000 at the low risk end of this, which is sort of the light touch over 30 years, really, because of sometimes it's about their monitoring strategies, how much they're investing in it, which gives us complete confidence to start with, and we're just checking that that's actually being used and implemented. So then it goes up to being much more bespoke, depending on complexity, size of schemes, what's involved, who's involved, and things. The standards, the professional capacity and experience of people. So, in more detail things, are we going to need FISC level accreditation of botanists and things? And that's the kind of thing that we're thinking about in that kind of wider picture of risk and standards. So the more we see of that, the more we work with, I guess the more we can bring the costs down.
Sorry. So at the start, you've got the due diligence and the conservation covenant, which is a more discrete bit of work up front, which is in the realms of 5,000, something like that. That sort of ballpark, again, dependent on the amount of information, the complexity, but it's around that for each of those two elements to get the thing started underway.
So and the legal agreement part,
and then it's the longer term stuff, obviously.
It's £10,000 roughly, depending on complexity, how much information they've already got. Do they need the land searches? Most people have them. We're just reviewing it. So we basically provide a sort of more bespoke schedule of costs as early as we can from the information that we get through our conversations, basically, in the process.
But I think it's worth saying that conservation covenants and BNG is replacing what I've seen over 30 years of doing this, which is mitigation that gets delivered on development sites and is only looked after for a handful of years. Isn't really an enforcement. There isn't any money in the local authority to enforce or to oversee, and this is why we're in the state we're in now currently, frankly. And I think you do need a stronger degree of regulation of this to make sure it works. But that's the bottom line for us, is we want enough involvement, and it, as Tim was saying, it depends on the level of risk. If we're really content that we know what the guys are doing and it's very straightforward habitats and all this sort of stuff, then it's a much lighter touch. But the ultimate question is it going to work? Is it going to deliver the restoration of habitats that has been committed to? That's the overriding question for us. And so the costs are kind of worked up proportionately with that always in mind. Okay, I've got a couple of other questions, well, several other questions. This one's probably for you, Natalie. How would a conservation covenant work for a development site with more than one eventual owner? I mean, it's not so much development sites that we're working with. Go on.
Can you say the question again, John?
How would a conservation covenant work for a development site with more than one eventual owner? I mean, I'd start that off by saying most of the conservation covenants will be doing it with a landowner who's got a separate bit of land that they're uplifting the biodiversity of, where they would be selling those to developers rather than it being a development site.
Yeah, I mean, there are sort of two situations. If you had a development that was going ahead and you had one landowner who owned the land and one developer building the land, and then that got separated out, it's similar to how you would do that with sort of a freehold and a lease. Essentially, it's a similar kind of process in a way. So the conservation covenants would be with the initial landowner who wanted to secure that on the land, and then that conservation covenant gets attached to the whole title of the land. So when that land is then parcelled off and sold on, so you say you had one area of land and you sold it in 10 parts, that conservation covenant would still bind each part of the land, and the conservation covenant would be a land charge on each parcel. Another situation you could have is when you have lots of different landowners, like a farming cluster, who all wanted the same conservation covenant system, but they were all different owners, in which case, because it's simply a private contract between individuals, you can make it very creative. So you can have one conservation covenant that everybody signs and binds the whole of the land. And then again, it would be between the responsible body and each landowner. And then that would again sit on every single title of the land, so that when that one parcel of the land got sold, it would still apply to the new owner within that cluster.
Thank you. I mean, I think related to this is the fact that you will often have a development which will have a bit of on-site delivery of biodiversity in that gain, and there might be an offsetting site as well, which could be all part of the same development. And often the on-site currently is being dealt with by Section 106 through the planning, and the off-site could be done separately as a conservation covenant. It would kind of be neater if it could all be wrapped up into one conservation covenant, because ultimately the on-site and the off-site are both required to deliver the uplift of 10% net gain for that development. So
I think that really depends on your local planning policy, because local planning authority, because in theory conservation covenants can be used for both on-site and off-site. As 10%, if you're looking at B&G specifically, as 10% mandatory net gain is a implied planning condition, it's not an implied planning obligation, it's a condition of your planning. You could say to the local authority, actually, we're going to do everything through a conservation covenant, are you happy with that? But because it's going through the planning process, that has to be approved, and the local authority may say, actually, we want this to be done by Section 106 agreement on site, and you can have your conservation covenant off site. I think until we've got really a feel for the process and had a lot of them go through, we're not going to know how each local authority does it. And it might be that some local authorities say we've got a loss of pressure and we want to relieve that pressure, in which case we're happy for you to have a conservation covenant. It might be that some say, no, we've got our specific process and we want to do it this way.
Okay, thank you. Okay, another question. Are you willing to enter into conservation covenants for anyone, landowners and developers, or do you have a minimum size of site, number of units, etc.? And this is from the person who asked the question about standard and bespoke costs. Who wants to take that?
Yeah, so I don't mind. So obviously, sort of extending on from the costs, we're not specifically bothered about the sort of minimum size, but because we kind of have a bit of a threshold cost in terms of, if there's getting to site, etc., then it is more viable once you're kind of going to sort of 10 hectare plus size and becomes really, really sort of viable higher than that, basically. So there is a level of where that looks more attractive. But in terms of us, we cover England, and we can be quite bespoke. If there's a cluster in terms of sort of same location from the same habitat bank, etc., then we can work on sort of more bespoke program linked to that.
I
just
think
in terms of efficiencies.
It's not just the size of the site that's important, it's the level of risk. So we're actually, we're not required to go into a contract with anyone. So we can kind of pick and choose. And I think we'd be, it's less attractive for us if it looks like a very risky opportunity. So, we take into account, what the nature of the organization we'd be contracting with. If there's a great deal of risk of litigation down the line, we might be, less inclined. Sorry, my phone's going. We might be less inclined to go into a conservation covenant with an organisation like that. But as Tim says, it makes more sense on bigger areas. Also with organisations that are doing the monitoring, and we're just doing kind of compliance monitoring. Natalie, anything else you want to add on that? The sort of people that we would contract with, given how many you've talked
No, I would just make it clear that the conservation covenant has to be between the responsible body and the landowner. So there's a bit of confusion sometimes when you talk about the developer or the land manager. You may have situations where there's a developer or a land manager that's contracting with the landowner to provide something, and then you have a bit of a sort of three-way agreement really, but the landowner would always have to be party to the conservation covenant.
So the more obvious agreements that we would have would be someone who's a landowner who wants to diversify and create a lot of habitat on their land and create a habitat bank and go into an agreement with us on that. That's kind of the more obvious route, because those habitat banks are then what a developer would buy units off, and the developer is not having to go into this contractual agreement. They'll have a contract of sale with the habitat bank to buy the units off, but otherwise, they don't have any liabilities. There's no, they're paying for those units, and that's about as close as they get involved, unless the developer wants to create their own offset specifically for that site, which we're also looking at.
Yeah, but it might be that the developer finds a site that they want to use and they don't want to buy it off the landowner, they don't want to lease it off the landowner, but they enter into a contractual obligation with the landowner, who then provides that. So it's a similar thing, but instead of just buying the unit, the developer is a bit more on hand with what happens on that site. But you can have a bit more flexibility with the conservation covenant as to who gets paid and who becomes a party to what.
And next question is one that I've had a couple of times, which is that in your enforcement section, you talked about obviously the conservation covenant failing in a sense if a business disappears. I think you did sort of mention that would be dealt with through the administrator of the bankruptcy. Is that how it would work?
You can have break clauses in a conservation covenant. So, for example, you could say if this unit has not sold within 5 years, then this is dissolved. It's really what's agreed between ourselves and the landowner. We would want to see the B&G working, no matter what happened. But obviously, understandably, for somebody to want to buy units and sell units and manage units on the land, they need to be not bound by this forever if it's not working out. If somebody does go insolvent, there is it's what you can agree in the contract. You could agree that it becomes a complete breach and disappears, or if you both want the land to continue with the enhancement, then you can agree that it just binds the land full stop, and then it passes to the future owner.
Which is what we would look for, presumably, because we're here as a regulator to make sure that the habitat that's committed to is created, right?
Yes, in an ideal world, we would want it to carry on through every single owner, but understandably, if somebody is creating a habitat bank, they want to be able to manage their units in a way where they know that they're not going to be losing money down the line.
Okay, look, there's a bit of delay on the line, which is a bit awkward. I'm going to ask one more question, and then we'll wrap up. So it's quite a long question, I'm afraid. From a development perspective, our preference might be to have the covenant on land ownership within which the development is located. I assume the nature of the system is such that the covenant can be secured on unrelated land, subject to the other landowner agreeing, of course. I'm just thinking about sites where the availability of compensatory is minimal. Did you get that, or do you want me to read it again?
You read that again. You broke up at the last sentence.
Oh, sorry. From a development perspective, whilst a preference might be to have the covenant on the land ownership within the development which the development is located, I assume the nature of the system is such that the covenant can be secured on unrelated land. I mean, that's what it is. It's kind of often is off-site.
Yeah, so
land.
you can have off-site.
So thinking of off-site where availability for compensation goes. Yeah.
If it's used for, if you wanted off-site for B&G, then you can use a conservation covenant for off-site land. But Tim can explain a little bit, because there are some situations where if you've got if you use the statutory metric to measure your uplift and your baseline, there is sometimes a preference for closer land, and you can get penalised or lose points for land that's further away. But Tim's the ecologist on that one.
Yeah, so obviously the conservation covenants can just be applied to any piece of land that you want. Obviously linking it to the kind of development needs, significant on-site delivery is one of the key things that might want some kind of security in conservation covenant. But in terms of other land, there isn't a restriction. I suppose it's just what the sort of, whether it makes ecological sense, what's being suggested, and then your actual scheme and process for sort of bringing that other land forward. How far away is it from impact? Some LPAs are very much against the sort of more national market, so they're much more restrictive from conversations we're having. So a lot of it will be quite local context, and other areas seem to be happy to sell credits from a site to anywhere almost. But there is obviously within the metric a penalisation in terms of sort of increase in size required, etc., because the further away it is, the sort of less bang you get for your buck, basically, and it costs you more. But yeah, in terms of
And this is really
practice,
this is really a situation. Yeah, so you're delivering on site if at all possible, and if you've got a big requirement, then you can, as a developer, you can buy some land. We've got a site near Stansted Airport where we're doing this. So you're acquiring the land as a developer to do the offsetting for your site, in which case you as the developer would be the landowner, and then you'd have to enter into a conservation covenant. The alternative, of course, as I say, is just to buy units from Habitat Bank.
As an ecologist, I'd say a larger strategic located sort of delivery of habitat is going to be better than just trying to force it on site or right next door to developments anyway.
Sure. Okay, look, we really do have to wrap up. There are some more questions. As I said at the start, we will follow those up afterwards and get back to you by email. Thank you very much for listening. I will just say that the next First Thursday Club is on the 6th of June, and that is entitled Climate Risk and TCFD, so that's Task Force for Climate Related Financial Disclosure, catch title. Navigating the Waters of a Changing Climate, and that's from Libby Robinson from the Nature Positive team. Don't forget, you'll get the feedback form about an hour after this. And thank you again for listening, and have a great rest of your day. Bye, everyone.
Thank you all.
Thank you. Bye.